Welcome to Probate Weekly. I'm your host, Bill Gross, at Bill Gross Probate on social media. We host Probate Weekly live every Thursday, 4 p.m. We live stream it on YouTube, Facebook, LinkedIn, Twitter or X, Rumble, Twitch, any place else I can get it done for free. And normally we interview attorneys across the country to learn about how we as real estate agents, investors, and attorneys can be better in serving our clients in the space of probate administration, probate litigation, and trust administration. Most of the people like me are from California. That's where I'm from and most of my following. But we interview attorneys across the country for a couple of reasons. One is so when we get referrals in other states, we have a trusted professional to send them to. Second, what I found is that the principles are pretty much the same across the country. The rules are slightly different. Now, I'm not going to tell you that's how the law is in Georgia and Alabama. Tanner Pittman, our guest today, who's an attorney serving those states, will. So welcome. If you watch my YouTube channel, you know I did an interview with Tanner. We had a lot of fun together. We went a little overtime because I enjoyed chatting with him. Tanner, thank you so much for coming to our show today.
Hey, Bill. Thank you.
Now, I think I had that right. You're in Georgia and Alabama, correct?
Yes, I'm in Alabama right now as we speak, but I've got an office just over the river in Georgia. So East Alabama, West Georgia.
You're in Alabama, so I'm just bragging right now. And my roommate in college was from Alabama. I think from where's all the space stuff at?
Up in Huntsville.
Huntsville.
I went
Huntsville,
to space
Alabama.
camp in Huntsville. Yeah.
I don't know you know an attorney, Carl Leo, but he was a roommate of mine in college when I was a freshman. But very proud Bama, and so you know in Alabama they love the governor. Anyhow, so you're attorney in.
They do. Yep.
Some years they do, some years they don't.
Right. Yeah. Boo, boo, boo.
So tell me about law. How'd you, first off, let's go back a little bit and learn a little bit about you. How'd you get into the practice of law? And then how'd you get into particular estate planning and probate particular?
Yeah. Well, so for law practice, it's easy. I studied international business in college because I enjoyed languages and yet in short order, as I got into business internships, I discovered I couldn't sell anything. I was in Germany one year as part of my studies, and there was I was at an event where I was hired as part of the event organizers, and I was to sell little cheap parkas to Germans in case it rained. And it was an outdoor venue, and they all had to be there outdoors. And they cost like 5 Deutschmarks, so like a $1.75. And it started pouring, and I couldn't sell the rain parkas to soaked Germans. So it was then that I knew I had a calling in the law, where salesmanship is not, unless you're talking to a judge, it's not required.
Well, that's an interesting place to start because I've got a first question up. Evangelist Marvelia Harbin, is there from California? The answer is no, mostly California, just because that's from where I'm from and mostly known. But we have an audience across the country, and today's attorney guest is from Alabama and Georgia. You know, I think that's an interesting point that you're not the only attorney who went into the business because they didn't want to or could not successfully sell. And I think that's I'm not knocking, I'm just saying, right. And I think as a salesperson, I think my goal is that people call me so I don't have to sell either. That's really the ultimate marketing, is people to choose to work with you. My father was an attorney, an old style attorney where advertising wasn't even legal in his day, right? The only way. Yeah. And so that's why I think in particular, your profession has that history and culture that they don't want to sell. And I think that's where we as real estate agents can be a great team member because by our nature, we're salespeople, right?
We are. That's true. We are an organized cartel. And if you were a lawyer, and I don't need to tell you this since your father was a lawyer, but if you were a lawyer and you had a client and I called them up and asked them to come over to me, you would and should report me to the bar for solicitation. It's just it's illegal for all intents and purposes.
But it's even more than that. It's even more culture that used to exist where it was unseemly. I know when the first advertisement started on television and radio, and billboards, it was very unseemly or thought to be. I think, though, it also forced some competition that forced prices down on more routine services, but that attitude still lingers today. And so I know that your focus is on estate planning. Let's talk a little bit about where does marketing for you begin, and because it sells, that ends. What does that look like, and what does it not look like, your participation as far as generating business in estate planning?
Yeah. So we do estate planning and probate, trust administration on the one side, and then we do some estate litigation on the other. So both transactional side and litigation. But marketing, such as it is, well, yeah. My first job interview with a couple lawyers just out of law school, whom I wound up working for, I asked them that same question: What do we do to get business? The one of them answered, "Do good work," and that's really kind of where it starts and stops. So really, just referrals from existing clients, and crucially for us, from other lawyers. If you're specialized enough as an attorney, you're obviously, there are fewer people who demand your exact services, but correspondingly, there are fewer and fewer lawyers who do exactly what you do.
Right.
So they eventually, I mean, if you know, as we all do, 20, 50, 100 other lawyers, and if they know what you do, they're going to send you those clients that need your specialized service. Existing clients, other attorneys, and then just kind of like what you do, Bill, you just have a coffee with another professional once every week or so. And if you've got a JD after your name, people just assume that you're reasonably intelligent unless you prove otherwise.
Yeah.
Hopefully I haven't done that so far in this interview. And they will, you do that 10, 20 times, and eventually folks will be referring you work. You try to do it well.
So, and that was the phrase you used when we met one-on-one before, that do good work. And I think that good work for us as real estate agents should include marketing the importance of estate planning to our clients and referring them to an attorney, which sounds to you like sales. For you, that would be, but for us, that's good work. Meaning, if I know somebody owns a house and doesn't have it in a trust, I really have an obligation, if I'm going to do good work as a realtor, and say, have you explored the advantages? Are you aware of the possible problems by not having it in a proper estate plan? And so I can introduce you to somebody who can give you a consult to help you understand the risks, the rewards, the costs, and to move forward. And so I think for us, do good work could sound like just really worrying about your customers, taking care of your customers, and getting them involved into the process. And so I think that's really that phrase stuck with me for a while. I think it rubbed off. We talked a couple months ago, so I need to hear that. I think every month, do good work. I think it's just that should be your motto. I think that's fantastic. So let's talk about, what does good work in estate planning look like? We'll just take that niche for now. What does good work in estate planning look like as opposed to not doing good work? Like, what would you say are, if you were evaluating another attorney's performance, or your family member come to you with a plan, what would you look at as the barrier to say this is good work or this is not good work?
I like talking to you because, like you mentioned from our last talk, you know a lot of this. It's rare that I meet a real estate professional who knows just as much as you do about this kind of thing. But so I bet you anticipate my answer. But the answer is, with estate planning, many estate planning lawyers see themselves as form pushers. So, if I've got Bill Gross's will and his trust filled out, like filling out the form, then I've kind of earned my fee. And obviously, I'm going to say that it goes well beyond that. Good work includes really getting a thorough understanding of what is. So what does Bill Gross own? What's his estate, and what does it consist of? Is he going to inherit mineral rights in Colorado 10 years from now, and we need to figure out a plan for those, in addition to just his house in California, and then obviously on top of what is, also what we're going to do. In Georgia and Alabama, probate is much easier, I understand, than in California. In Georgia, especially for various kind of historical reasons. Uh, and one consideration is whether we even need to worry with living trusts for a client. So you need to know kind of what to ask clients in that vein. But having a good grasp of what it is, so really taking your time with a client, or having your paralegal take their time with a client to go through interviews there, and then being real clever in your approach. For many Georgians, especially, it's a will with maybe some testamentary trusts in there, but it's also helping these clients. You know, stop me if I just get long-winded about this, but it's helping these clients in an almost ongoing way. So just your initial contact with them, and then year over year, helping them understand that one of the biggest problems when we die is that our children have no idea, or our, heaven forbid, it's like our brother, and our children just somehow aren't the executors. They have no idea what our financial lives consist of. Everything from the bills we have to daily pay to keep things running to where our investments are, let alone insurance policies. So keeping all of that together and organized is every bit as good and important as a well-drafted trust. And not 1 in 10 lawyers keeps on top of people about that, because we tend to want to take our flat fee and then be done. Right. And clients are kind of accustomed to that too. So I think there's education that needs to go both ways. Both lawyers need to be more thorough, and clients need to understand. Yeah, you might need to pay for some checkups every few years.
Yeah, I think that to me is, again, when we spoke previously, I think one of the things that struck me about why I liked you and booked you for this guest spot is because it is important to me that we're creating a relationship or not, right? If you said to me, I'm just a transaction attorney, and I'm gonna sell this property and I'm gonna manage it for you, fine. And I'm just gonna do this estate plan and it's perfect today, but going forward, you need to get an attorney to help you. But I think that people walk out with the mistaken assumption that binder they have now protects them, and the binder doesn't really do anything. It really is, executing the plan in the binder, and often needs the author of the binder to help you understand what to be done, or help the heir what to be done.
So we give out a pretty binder too, and if you don't do the work behind that, you've just given people a false sense of security.
Right. In California, one of the main issues, one of the main, I think, standards that I won't refer to unless the attorney meets that, but most don't, is the funding of the trust when there's a trust involved. So in California, we even have a fallback provision, which is, I think, unique to California, where if it wasn't put in the trust, but it was intended to be, and that gets decided in court, there's something called a Hexit petition where you can put it back after death into the trust. Most states don't allow that. So how do you remedy clients coming in your office? They're with you, they're excited, they're motivated. You give them the binder, confetti, balloons, horns, rainbows, unicorns. They walk out the door and don't do anything. How do you trust customers who that's their plan?
Yeah. Well, yeah. So what you said, just to hover over that for a second, that's so right. Like, we don't have. If you're an Alabamian and I draft you a great living trust and 15 years rock on, and you buy some property down in the coast and don't put it in your living trust, then you're right, it doesn't go back in.
Right.
But by virtue of some petition after you die. So, we, like California attorneys, just to address that one problem, we do a backstop will. We call it a pour over will. I'm sure y'all do too.
Same term.
Just because we can't resist the metaphor of pouring alcohol from one vessel to another. That just seems to be it's like a common one for lawyers. But you do that, and if you have to probate that thing, then you do it. And the notion there, Bill, as you already know, is just, it's a simple will that says, by the way, Bill has died and he has this trust, and anything he neglected to put in the trust actually just goes in the trust. So your trust becomes the main vehicle that you would amend or anything to change your plans, and your will just scoops everything into it.
In Georgia, Alabama, what's the process to do that? Is it a petition to court? Is there a court hearing process? Is it as complicated as a probate or not as?
It's a probate.
Yeah.
Sure.
Yeah.
Alabama has a truncated probate for smaller estates. Georgia actually doesn't, although it's got its own little interesting things. And it is just like I think any state. The notion of probate is you file your petition, you notify all of the heirs at law, anybody who would stand to inherit if you died without a will, and you've got to either get their consents, or maybe they get to come to the court hearing, maybe they object, or maybe they don't, and then you've got to, of course, you got to notify any would-be creditors, and depending on the level that the state requires of assiduousness there, you've got to either find them out yourself or either just publish notice. And then some states, Alabama included, have a statutory amount of time that goes by before you can kind of feel safe distributing and all these things. So there's a lot to do there with probate, and you want to avoid, if you drafted a living trust anyway, you want to avoid having to get hit on both ends, both for the attorney fees for drafting the trust and then for the probate after you die, having your ears hit.
I think both Alabama and Georgia are destinations for people migrating in.
Yeah.
More in California is more migrating out. So you must have some people move in who have perhaps assets and a plan from another state.
Right.
They're moving into Alabama and or Georgia. Do they commonly have to write a whole new plan? Do you review it? What does that process look like?
Amazing how many people come in without a funded living trust, as you just said. Like,
they have a binder, though.
Yeah, they get a great binder. Most times, by the time I've sat down with them and talked it all out, we're almost drafting a new one. It feels like it shouldn't have to be that way, but a lot of the fee is really sitting down. Bill, you've moved to the coast in Alabama, and now you want to update your documents. A lot of my fee is just sitting down and figuring out again what all you have and what your goals are. And by the time I've seen whether your California documents make sense in our state, I've already done all the same work I would for an Alabamian.
Right.
Because, of course, if I get you in my office, then I own any problems that were in the existing plan. I've got to search through all the issues again. And you do have those clients that come in and say, well, I would just like an update just to make this Alabama friendly.
Right.
And that's all fine and good, except, if a few decades rock on and the trust becomes irrevocable and there was a problem, then everybody's going to feel like you owned that problem.
Right.
It wasn't just, for an update. So you almost got to.
Well, and you would have to review the whole, not only the person, which you mentioned, but you'd also have to review the whole document.
Yeah.
Right. And almost as much time to review the document.
The whole thing. Yeah.
And draft an amendment in different styles and laws and provisions that I went through that recently with a lease agreement for a client where the seller had the owner had a lease agreement, a contract, and the client sent to an attorney, spent $2,000 and marked it up and sent it back. And the seller said, "Well, how much did you spend for that?" He said, $2,000. He said, "Well, I only spent $2,000 to review it. I paid my attorney $2,000 to create the document. Sign it or don't sign it. I don't really care." Yeah. And at some point with an estate plan, it's kind of the same thing, that you should go in and expect that. Though I do think they can help you save time, I imagine, by bringing into plan, but more importantly, reading it and saying, are all the assets up to date, and knowing what other information's missing and gift you ahead of time.
Yeah, that's right. It's true. If a clients come in with varying levels of preparedness, and with a lot of things we kind of flat fee them, although many of our plans are, say, 4 flat fees for various things built on top of each other. If you have a very prepared client come in who explains that to you and says, really, I don't think you have a lot of heavy lifting to do, and then shows you everything that they've got titled properly, a lot of times we'll say you're right, and we're not going to charge you just for the paper push. I can't charge you thousands of dollars just for having a paralegal fill out some forms. So that is a client that can save some money. Other times they need us to walk them through it again because it's been 12 years and they just forgot, just like I might if it weren't my bread and butter.
It's funny. I was on this call with another attorney on the same topic about a year ago,
Yeah.
and I was kind of laughing at people who think they need to update their plan. And I realized, you know what? We have our money in a new bank account. I don't think that bank account is held in the trust. And over my shoulder is where I used to keep the binder that we had in that particular bookcase. And I was thinking, oh my gosh, I'm on the call making fun of people who haven't updated their plan, and my plan's not up to date.
Yeah.
I scrambled and got that fixed. So
it's always important, but never urgent. And
yes,
most folks just let the urgent become the master of the important, not the other way around.
Or the relatively urgent become important rather than the actual urgent or the important stuff. No, 100%. That's absolutely right. Let me do some housekeeping real quick. This is probateweekly.com. We do this every Thursday. We live stream at 4 o'clock Pacific time, 7 p.m. Eastern. I want to thank Tanner for coming in from Alabama and Georgia after hours with us today. But we do this every week. We live stream it on YouTube, Facebook, and LinkedIn. If you're watching on the live stream, feel free to put your comments in. I'm watching for questions. I'll try to answer them as best I can. And if it's after hours, I'll either get to them or forward them to Tanner as appropriate. You can sign up for reminders at probateweekly.com. Just put your email address and register. If you scroll down, you can find us on the various audio platforms. We're on Apple and Spotify and all those places. Love to get a review if you're on any of those platforms as well. And if you want to see the past episodes on YouTube or my YouTube channel on Probate, I'd love to have you join us there as well. You can continue the conversation on Facebook at our probate group, which is Probate Weekly. We have 3,900 members. I'm trying to get to 4,000 here. But you not only can you ask for questions for referrals for attorneys or realtors in other states, but also post your probate or trust-related content on the website. Here, Kevin Bemmel has a regular podcast, Trust and Estates Weekly. Love to support him. Also, I think Courtney Rollins in North Carolina as well. So feel free to put your content there so we can like each other, share each other, support each other's business. Love to have you guys participate there as well. And then, never mind that. Our guest today is Tanner Pittman at tannerpittmanlaw.com. He's an attorney in Alabama and Georgia. Today he's in Alabama, but you might snap his fingers and be in Georgia. You never know where he'll be between the two. Practice law in both, specializing in estate planning, probate, and estate litigation. So let's talk about what would you say are you do estate planning, but then at some point somebody passes and it turns into administering the estate. Most commonly, we trust administration. So talk a little bit about your role as the attorney in the trust administration. I know I get phone calls from one of the heirs. Hey, my brother's running this. He's not communicating. I call the attorney. He's not returning my phone calls. I don't know anything about the trust. They haven't even sent me a copy of it or anything. So talk a little bit about the common challenges and problems in trust administration.
Sure. So there's trust administration, and then there's kind of meat and potatoes, probate and administration of an estate. And you're right to say trust administration is special because, if someone has drafted my trust, if I have a trust rather, and I die, a trust, and probably most of your listeners know this, but a trust it's like a contract. It's just a very special variety of contract. And you don't have to, before I die, you don't have to file it anywhere. You don't register it with anybody. It just exists in some paper in a drawer somewhere. Of course, everybody signed it and it's binding, but it's only that. It's a contract. And just like any contract, I mean, Bill, you probably got some contracts. I don't have a right to see them. And the same is true of my trust. Now, many states, Alabama and Georgia included, require certain notices to trust beneficiaries if you die and it becomes irrevocable. But in broad terms, we can say that I've got a trust, I die. Let's say that you are you're my heir, but I've disinherited you in the trust, or I haven't given you any property. In broad terms, you don't have any right to make inquiries into that.
Yeah.
Like why would you? Why do I have a right to look at your contracts in your desk drawer? And that's kind of part of the magic of a trust for the drafting party. He or she may want to disinherit a child. or just keep everything private. But it's very frustrating. And like most lawyers, I've represented people on both sides. It's very frustrating for those of us who feel like something was amiss or smells funny in the way that, like, the trust was drafted, who want to figure out what's what. So, I mean, there are all kinds of cases that arise, but broadly speaking, I think the scenario you gave was, there's been a death. The family suspects there's a living trust, but some member of the family isn't giving notice to anybody and isn't communicating. What do you do? Well, a lot of different things, but one thing broadly you can do is that, trusts are finally within the province of any court of general jurisdiction. So in Georgia, those are called superior courts. In Alabama, I'm trying to think what California calls them, but anyway, in Alabama, they're called circuit court. Okay, yes. California's like Georgia. In Alabama, they're called circuit courts, and in New York, interestingly, they're called supreme courts.
Mm-hmm.
And anyway, there are things such as a petition for an equitable accounting in those courts of general jurisdiction, or just kind of a garden variety petition alleging some kind of fraud in those things. The trouble with trusts becomes that you don't want to just file a petition, a groundless one, or you're going to have attorney fees assessed against you.
Right.
So what then? Do you have to file it to figure out what's in it? Kind of like people, chided Nancy Pelosi about saying about the healthcare bill. Like, and the answer sometimes is yes, but many times what you do is, you're the lawyer for one of the family members who's upset. You figure out who's representing the trustee, and you call them up and you say, here are the reasons I think either the trust itself was somehow fraudulent or something, or that your client, the trustee, is doing things wrong. Now, we can go one of two ways with this. You can either kind of show us your cards a little bit and shut us up, because they always say that they're doing everything above board. And if you are, then we'll, put us in our place and show us. Or we can jump ugly and file something in superior court if we're in Georgia. Part of the beauty for drafting parties is that's actually a little bit difficult to do, but there are ways through there.
What's the cost to file? Like you said, you have to almost file or be ready to file. You have to hire an attorney and give them some sort of retainer or her. What's the cost to kind of get to that point to find out what you have? Is it, you talking about $1,000 problem, a $5,000 problem, a $10,000 problem?
We take a retainer and get going. It's on those things, you almost can't pull a price off the shelf and say, this is a $980 petition for equitable accounting. You usually take a retainer, and I mean, I won't necessarily throw out what mine is, but many attorneys say $5,000 or $10,000.
Yeah.
As we get into litigation.
Yeah.
Because and those things, if you're in for a penny, you're in for a pound.
That's the challenge there with litigation.
Yeah, and your client, your client has a lot more power in terms of your relationship than I think is commonly assumed. You hire me to represent you in superior court, and I've taken a little $500 retainer from you for argument's sake, and it starts to snowball. I'm still your lawyer and still have to represent you zealously,
right? Even
if you're being really slow with paying the rest, until or unless I withdraw. And withdrawal is a whole process, and I've got to obtain court permission. So usually I've got to be covered up. I mean, in terms of with a retainer.
And that's the point I think many people understand is that you, as an attorney, you can't just say, "Hey, I'm done. I'm canceled." Fire the client. You literally have to file a form, at least in California, with the court. And the court has to approve it. and the judge might say no.
Yeah, he might, right. If we've got let's say we've got a motion, an argument on a motion for summary judgment pending, which for the uninitiated, that's a big, important argument. I can't drop you 10 days before that argument because you'd be so high and dry. Right. I've got to literally spend all those billable hours briefing that and then going to court and arguing it. And I may or may not get the rest of my fee from you. So
that's why such a, I'm sorry.
No, go ahead.
I was that's why it's such a big deal litigation. People say, well, what's the big deal? Just file a form, and it's not that simple. Like you say, in for pound, in for penny, in for pound. But I think more than that, the attorney can't just say, you can hire me for this filing. You're either representing the client or you're not, and that is more involved than merely filing some forms like a paralegal might. And that's why those people end up with, I think, the right direction is pro per, get a paralegal, file the forms. You're representing yourself. Everybody gets to tell their day with a judge, and good luck. One of the areas that commonly comes up now, I don't know if it's as common in Alabama and Georgia, is elderly clients and a last minute or relatively last minute grant deed or trust or will that is by a caregiver or by a late term friend who becomes a girlfriend, or the one son or daughter who ends up claiming that they gave care. And so the issue is, mental competency. So describe a little bit what cases that you've come across that you've been successful at helping families stop abuse, or what the challenges are there that tells them in some cases there's not much you can do.
Yeah. I don't know where to start. We've done cases on both sides of that kind of equation. So one of my first will contests, we had drafted a will for a 103-year-old woman. As I sit here, she was competent to make that will, and everybody knew that really there was only one soul on the planet she'd want to leave her estate to. But she had a half sister who was her closest heir at law, her children having predeceased her. So by the time you're 103, there's a decent chance you're going to outlive your kids. And she was just like that. And she had a half sister that came and challenged the will. And doing a will challenge is difficult if you've drafted the will. But the upshot of the will challenge was that it was in our favor. She was not successful. And yet, looking back on it, I mean, there were a few things. I was a fourth-year lawyer at that time, and I knew that she was competent, and everybody did. But some of the mojo has got to be just try to avoid litigation.
Right.
And we could have done some probate avoidance things, such as changing titling of her major assets while she's in life, or do things like potentially. This can kind of backfire on you sometimes, but do some videotaping of the signing. One of the things you do with a will that comes out in litigation that people don't do in practice a lot is, like, a lot of folks don't actually read all the way through that document. We have a line at the end of it that says, "I've read this," but we haven't. And it is embarrassing to be on the stand and say, "Yeah, I'm not sure I saw my client read all of that." So experience tells you that it's good to get those things really buttoned up if you think that there's a chance for a challenge, and or move those assets outside of probate. My remit for that 103-year-old woman was write a will. That's really all her family wanted me to do. So I just did it. But had I been a little bit more forward looking, and had I known a challenge was coming down the pike, we could have done a deed. Her biggest asset was a lot of land in rural Georgia. Anyway, but the other side is where you've got the clients who know that there was some impropriety in the making of the trust or of the will, and some things are generally true about those clients. any attorney who does these things is like nodding their head as I say this. Those clients always know that there's like 3 to 5 times more assets in the estate than there really is. Like they're sure of it. Almost as a rule, the estate is smaller than the clients think it is, unless it's the wife and she just happens to know. But children tend, and especially more remote heirs, tend to overestimate the size of an estate. And they almost always, and here I'm talking about my clients in will challenges or trust challenges, they almost always lean very, very heavily on what was said to them even years before the decedent's death, just very heavily.
Yep.
And it, especially, I don't know why it's true of us, but especially men have this tendency to want to say at various times just the thing that we know will mollify somebody, and then everybody can sort it out when we're dead. And so we'll say things, hey, you're definitely gonna get the farm, and then we put in the will that our whatever, third wife gets the farm, and this engenders bad blood. But anyway, I think you asked me, what do I do? One of the things you want to do is control expectations. Another thing you want to do in these challenges is move very quickly. If you're the challenging party, and Bill, stop with more questions if I'm just rambling on here. But if you're the challenging party, already by the time a client's coming to me, someone else has been in charge of the estate or has taken hold of things, and they've had the reins for a little while.
Right.
So they've had time to squirrel away assets if they can get their hands on them. So you really want to come in swinging. And a lot of times we'll do that with an injunction. I had a case where a young woman had about $250,000 insurance policy that her daddy, on his deathbed, all medicated, called the insurance company. Apparently you can call the insurance company and change the pay on death benefit.
Wow.
And he called him up, and it was through his employer somehow, and changed it to his then girlfriend. And my client was the daughter, and she had been the beneficiary, and he died 2 days later, say. And the best thing we did in that case was to quickly get an injunction. So, for your audience, an injunction being just a court order that people stop doing something. And we pled in the employer and the insurer into our injunction case and just had everybody stop. So nobody paid out the $250,000. And the judge was comfortable with that because it just meant that things proceeded in an orderly way. But it saved the day for us. So you got to come in swinging and jump fast if you're on the side of the challenging folks. Unfortunately, that means that many times there's not a lot of room for just doing what you want to do in families that should act like families. There's not a lot of room for just kind of making nice and negotiating.
It's tough.
Yeah,
it's
yeah,
so tough.
Right. Everybody circles the wagons, and it gets to where you're fussing at each other just right out of the gate.
Good relationships and families often are maintained through this process.
Yeah.
But bad ones never get better. They only get worse. More money put in the pile, the worse the cracks get in the relationship, and it gets to be a bit out of hand. One of the things that come up for us, we don't have the same responsibility you do as far as a client's competency, but we do get called in to sell a property, to sell mom's property. And mom may be, elderly and have some memory issues, some, cognitive issues, maybe is alert in the daytime, not as alert in the afternoon or evening. So again, not as an attorney, because you have different standard of, but what are the kind of the levels that you would say as a real estate agent, if we're going to sign a listing agreement to sell a property, what would the warning signs be that you've seen that turn into problems down the road?
Probably as soon as you think I don't want to ask this person that question because it might prove to me she's incompetent. That's warning sign. Like I get a client in the office and think, should I ask them where all their assets are, or will it just prove to me that they actually don't know, or do they remember their son's middle name?
And the hard part is you're
I think
trying to do.
we all tend to hope against hope that our client is competent enough, and as soon as you find yourself doing that, like Bill, I don't find myself wishfully thinking that you are competent. I can tell, but we all know the clients that we do. We're almost afraid to ask too many questions.
Well, I think the hard part is sometimes you're doing right by them,
Yeah,
but you don't know
yep,
if you have the legal authority
right,
to really do it or feel good
yep,
about it.
yep.
Uh, transferring property into a trust or transferring it to another family member to avoid problems because they just aren't going to do an estate plan. And so I'm going to deed it to my daughter or do
Yeah,
joint tenancy with my daughter. And they don't think through the tax implications. They don't think through the legal implications. But that probably is better than nothing. But it's, and so I'm sitting here saying, well, I know it's for her benefit. Who would complain? Well, the answer is you don't know who would complain, but somebody might. And now I did it. And so I think that's a great answer, which is if ever your gut tells you, are they competent? That probably as a professional, I should put the stop sign up, stop and reassess, figure out where we're going to go.
so hard to do in that moment, especially for y'all, because you've got a sale pinned, in the offing. If you sign somebody, I wonder. I've never been a real estate agent, but I wonder if in that moment the next thing to do is not to see if you can't rope in another professional like the family attorney or their CPA or something to even just give yourself some air cover.
In my experience, what happens is, having met a couple times and when I go, I know it's right, you get the phone call from one of the siblings,
Yeah,
and it's one of siblings. I go, whoa, this is obviously, and I'll go ahead and cancel the contract and good luck, because as much as I'd like to, if the attorney's calling me in, then I'm fighting for the client. But if it's one of the siblings, it's just too hard for me to unravel who's right, who's wrong, who's got control, who's competent or not. It really is well out of my pay grade to make those assessments. And I think
it's got to be tough when one client like that for y'all can make or break your month in terms of what you take home.
It's so important not to look at that. It's
right.
One thing I learned early in this career was you have to have at all times enough business where you don't think about the commission dollars.
Yeah.
Yes, at the end of the month, I look at my numbers and I was set that I didn't close the deals, but it didn't affect my paycheck or didn't affect my finances because you have to. And look, in a real estate, you should get at some point, just for those listening, one of the other podcasts I do is on real estate investing, Cash Flow Chronicles podcast. You should get to a point where you're living on your returns, not on your commissions. Your commissions should add more to your return, to your estate or to your pile. But if you're living on your commissions, you're going to make the wrong decision, and that wrong decision is never pretty. It's definitely an ugly process to be in. So, okay, we talked a bit about estate planning. Let's talk about straightforward probate and probate administration. Is that my sense of that business is getting slowly at the edges more competitive. There's certainly more. There's not more attorneys coming into it, but there are attorneys specializing in it that seem at the edges. The top 5 or 10% seem to do a lot of them and do them well, and that's kind of creating a little momentum. At least in Los Angeles, I see kind of practice getting a little bit better. The judges kind of seeing what's happening a little differently now. They've made some, I think, really good positive changes. Technology's created some visibility. Yet, I'm sure the attorneys are being squeezed on their fees. It's a tough business. What do you see as probate administration business as part of your business versus the estate planning and the litigation?
Say that again.
I guess I'm asking how much of probate administration is just pushing through the paper administration versus how much is really acting on behalf of your client, using your legal skills, filing, objections and answering objections. What percentage of it is just pure grinding the paperwork and getting through the process versus the confrontational aspects?
Sure. Well, so even before you get to the confrontational stuff, broadly, there are kind of two kinds of probate clients. The ones that want you there for the courtroom stuff, so filling out petitions, as you said, and getting the bond approved, those sorts of things that folks just aren't familiar with, and they want to make sure it's done, absolutely properly. And those, and suppose that first group of clients does all the rest themselves. They've got no problems, opening bank accounts and figuring out where all the assets are and doing an estate sale with all the stuff, all the nitty gritty that doesn't necessarily require a law degree. It's kind of one broad category. A lot of lawyers can actually even flat fee those probates. Another category, the other category, even before we get to contested, the other category is the client that, for whatever reason, won't do things like, okay, now I've got my letters testamentary. I assume that's what you call them in California too.
Mm-hmm.
Now I've probated the will. I've got my letters testamentary. Now I've got to just call a few insurance companies and go to the bank and then get someone to appraise the house and those things, all the things on the list, and call such and such a company to get the dividend. Many of them can't, and so we're not flat feeing anymore. We like to develop a checklist. Obviously, we've got checklists, and then turn that into a representation where there's, hand holding kind of as required. The beauty for the lawyer in most states is that there's a pile of assets there, so that your fee is owed out of it. So eventually you can settle up with the client. But with those things, many times you'll have your whole representation will be advising about that, and then having meetings where we update each other's checklists, and then finally capping everything off. So that's just the uncontested ones.
It seems to me that the biggest area of conflict between clients and attorneys is that distinction between the things that I would call the legal functions and the maybe administrator or executor that a fiduciary might do.
Right. Yeah.
And there are clients of mine who really can't do it. Like mom and dad left my house, but they're just, they're indigent. They're older. They're just not able to e-sign documents. They really can't get on the phone with the bank, and they really need somebody to either act as their fiduciary or literally be their fiduciary.
Sure.
As an attorney, I find that too often the attorneys say, well, I'm in the attorney lane, that's the administrator lane. I think that's great as long as you both explain that to your customer and vet the customer that they can't do that. And increasingly, I'm coming back to attorneys saying, really, your client needs, a fiduciary. And I know a company that will do that maybe at a limited scale basis, or they need a full service fiduciary that's going to cost in California as much as the attorney charges.
Yeah, we know them too. There's a great one in Atlanta, but I'm not going to refer her anything less than $1 million estate. And if I'm referring it to her, then it needs to be mostly, or at least a large part, liquid. It's just for her to be the fiduciary and that be worth her fee. She kind of has to do that. My paralegal has pointed out so many times what a gap there is in the market between someone billing at $250 an hour, and that's a country lawyer where I'm at. It's probably much more in LA. So between that and someone who just has some business sense and almost in a secretarial way could help handle estates. I think somewhere I think that company actually needs to be formed, where I can, you, Bill, you and I just have some general business skills. We form a company, and we just manage estates for folks and hire lawyers for the legal stuff.
Well, it's funny you say, because I actually have a vendor who's building that business nationally.
Okay, yeah.
Grivner.com. Byron Botras, I've had him on the show.
Okay.
And he started as a alternative to the attorney, and he would kind of create a boilerplate cut rate attorney, provide the attorney with administrative support. But he found, and he and I work on this together, their customers just can't sign the grant deed. They just can't, whatever. And so started doing the fiduciary work as well. And so I do think there's room for like a national fiduciary that would have a defined list of services or menus and come an attorney like you and say, here's our basic plan, here's our B plan, and here's our concierge level, and here's the prices for those things. They know the vendors. I agree. I think that's a real need in the marketplace that people don't want to pay for when you stay up front. But as a professional, I see the need for it. I literally have a new listing where it took them 9 months to get their letters approved from a good, decent local attorney. And the customer's mad at the attorney, but I can see where the attorney said, well, we mailed this out. They never replied. They didn't respond. We followed up with them. And so I think it needs a third person to kind of hold both hands and be the glue in the middle. So I definitely see that need. Sounds like you'd be open to that as a client, perhaps.
I don't know. I can't. I've taken on. I've had cases where I've become the administrator.
Right.
And we're extremely expensive relative to having whatever your business-minded uncle do it.
Right.
And obviously, as the estates get more and more wealthy, $4 million estate, okay, an attorney administrator is not expensive compared to the gains that you'll get from having someone handle that efficiently. My paralegal has mentioned, and in fact, it's kind of a dream project of hers to do what you just mentioned with Scrivener.com.
Mm-hmm.
And I've got all these folks who want to pay me $250 an hour. It's very hard to justify forming another little company of that kind.
Right.
It's out there, though. I agree with you.
So when you say attorney and administrator, do you charge more? Do you explain to the customer that you're really playing two roles and charging? Or is it just per hour? And because in California, there's a statutory limit.
Right.
Like in our state, it's limited at $23,000. But if you're also the administrator, you can charge an additional $23,000. Generally, you can't be the attorney and administrator on the same case. So attorneys work with each other and refer back and forth. Is it similar in Georgia and Alabama, or is it different?
So I think the $23,000 thing is California specific, but the rule where I'm like a pro se administrator of an estate. I face an immediate conflict of interest in as much as one of the heirs of that estate hired me. In the particular one I'm thinking of, there's really only one heir, and it was a complex, squirrely estate. He's not very business-minded, so I have an alignment of interest rather than a conflict of interest. But I had him sign a waiver anyway, just in the sense that I'm both kind of his private lawyer and I'm the administrator of an estate that he has a claim to. Well, yeah, but I've also got to serve the creditors of the estate. Right. I mean, as administrator, I'm their fiduciary too.
Right.
So the conflict's there, and you've got to make sure the client comes in very clear-eyed about that.
One of the tough things is I got a case referred to me by another realtor to be the administrator on a case through Scrivener.
You don't need the administrator.
So I've done a couple. In California, you can do two without needing to be licensed. To do more than two, you need to have a license.
Okay. Most
states don't. To my knowledge, no other state requires a license to be an administrator.
No, you could do 20 in Alabama.
So I've done a couple, and one was referred by a realtor to Scrivener, and they in turn asked me if I'd be the administrator, and I said, yeah, it sounds like fun, and I learned and did it. And it came time as a conflict with the realtor on his commission and some of the things he was doing. And I had to call, the realtor and say, look, this is a little awkward because you referred the business.
Yeah.
But as far as this goes, I'm the customer.
Yep.
And I have an obligation to my client to, get the best price and to lower the commission to a competitive rate. And so it's one of those things where I understand now attorneys, the challenge of referring business to a real estate agent. You have to be really careful about those relationships, because if they're giving you business and then you give them back business, are you going to turn an eye away from them overcharging because they're giving you business? So it's not such a simple thing to say, you should give me business. It's very complicated, I think.
Right. Yeah. Yeah. That kind of a referral is a tough one to do. We get even more complicated situations than just that.
So
Yeah, you want to honor the referring party, but then again, you wear this other hat where you have a fiduciary duty
right,
and can be sued for breach.
right.
So, yeah.
So last question, I guess, coming up at the end of time, but a lot of the realtors on the call are looking to build relations with attorneys. You said, I think up front, and I think do good work. And so, I always tell agents on my team, like we had a case where we're just now getting ready to file. And I said, look for an excuse to bring papers to the office, meet the receptionist, make her happy. If the receptionist's happy, the paralegal's happy, the attorneys to get good work, do what you can to help. But most importantly, on our listing, let's do a great job. Make sure the attorney knows we're doing a great job, and we'll get more business. What would you recommend to somebody who's looking to build their kind of network or their business in the Alabama or Georgia area? Not to necessarily put a bullseye in your chest that people should call you, but imagine you had a nephew or a son looking to get into real estate and wanted to work in probate and trust real estate. What would you recommend steps for them to take besides doing good work? What should they do for business development?
Well, I think you know this even before I say it. I don't put much stock in things like print advertising. If you're spending a lot of time on the internet tweaking your Facebook ad, I think you're really, especially in my market, it may be different in LA. But unless you have super skills at that, you're not serving yourself well compared to. I mean, obviously, my job is not sales, but it is good to have a network of professionals you work with. It's the best thing for me. If I'm looking, if you're in my market, Bill, or whatever, my nephew is, and he's looking to drum up business, I just think, calling up other professionals, hey, we've never met, let's have a coffee, press flesh, have a talk, have a couple pithy things to say, and I think there's no shame in letting folks know you're out there looking for work. And then, by the way, let's say you sit down with me, Tanner, who else should I be speaking to? Because I know some folks. It's not me. I know who you could be speaking to. Would you write him an email and say I might give him a call? I know that's a lot harder to do than to say, but good. I mean, certainly in this market, it's how everything gets done. And I it's a little bit different here than in LA. Go to church with them. It's part of it here. But then again, as a Christian, I'm not advising you to go to church for the contacts. But it is where folks meet each other.
Well, go to church. That's good advice. I think always. I'm Jewish. Go to synagogue.
Yeah,
you should go for other reasons, and that will bless you other ways.
That's right.
But I think you would point out the ethic of attorneys is there. Most real estate agents understand they're pretty quick to agree to go for coffee or lunch. That's kind of like an attorney activity that's unique to your industry, I think. Certainly pre-COVID. Now, COVID changed things, particularly here in Los Angeles, where the culture is different. But in general, and certainly outside of major metro areas, still going to coffee or inviting somebody to coffee or lunch is a kind of a normal practice of most attorneys. Most will say yes. You pick up the tab. Most attorneys will show up for lunch with you and meet you and give you a chance to talk to them, I think, is a general rule.
I think we get it. And if someone's going to be kind of cold about that, then you may not want to work with them anyway. But let's understand.
Yeah.
It's another professional, and we get that.
Yeah.
Don't be nervous about just reaching out to folks, even cold calls.
Well, I think I reached out to you cold, and look, we had friendship. And
you did, yeah.
Second time, I really appreciate it. I think I mentioned I had my friend Kevin, who has a trust estates. He had a probate in Alabama. His wife's mother passed away, and had to deal with that. We didn't know you then. Unfortunately. Yeah. So wish we had. So part of my job here is to have a network nationally. I really appreciate getting a chance to chat with you again and go into detail. And appreciate the insights. And I know I've asked some uncomfortable questions, but I appreciate you educating us today and sharing what's going on in your business.
Of course. I really enjoyed it. Thank you, Bill.
And everybody here, just real quick to wrap up, Tanner Pittman Law. Tanner Pittman was our guest today. He's an attorney who handles estate planning, probate, and estate litigation in Georgia and Alabama. TannerPittman.law.com is the website. We'll have that in the show notes as afterwards. And again, this is Probate Weekly. If you want to sign up, if you like the program, of course, you can like or share or whatever you do on whatever social media you're watching this on. But you also get reminders, register for the program at probateweekly.com. If you scroll down, you can also catch us on the various audio formats, Spotify, Apple, all that kind of stuff. And then if you want to see the past episodes, the YouTube channel there will take you to the past episodes as well. So thank you. We do this every live stream every Thursday at 4 p.m. Pacific, 7 p.m. Eastern, everything in between on either side. I'm Bill Gross at Bill Gross Probate. Thank you so much, everybody. Have a great week. We'll talk to you soon. Again, thank you, Tanner.
Bye-bye.